session this afternoon. I'm pleased to introduce Stephen Grieb as our next speaker. I've known Stephen for a long time. We've served on different councils and different events, and I can tell you there's probably nobody better suited to bring humor to Secure 2.0 and make this as interesting as Stephen. He's the senior compliance counsel over at Arthur Gallagher, has a law degree from the University of Iowa. We won't hold that against him in this country. He's also a CEBS holder and is on the corporate board of the International Foundation. So we have, in the famous words, I think, Jerry Reed, we have a long way to go and a short time to get there. So we'll now talk about Secure 2.0. Thank you.
Thank you, Sam. So, dearly beloved, we are gathered here today to get through this thing called Secure 2.0. Secure 2.0, the main thing you need to keep in mind is this is a massive piece of legislation. There's so many rule changes. It's really dizzying to think of all the different rule changes. We did talk about Secure 2.0 a little bit this morning. We're going to do things a little bit differently this afternoon to prevent overlap. This afternoon, we're going to focus specifically on the Secure 2.0 provisions that address retirement plans. And we're also going to go a little bit more into the weeds, go into a little bit more detail on some of the things that we talked about this morning and some of the things that we didn't talk about this morning. So there are a number of changes in Secure 2.0 that are mandatory. There are a number of changes that are optional. As we go along, we're going to talk about which is which. A number of the changes are effective now. A number of the changes are effective down the road. We're going to try to distinguish those as well. The good news is plan document amendments aren't necessary until 2025 for both mandatory changes and optional changes. So if you add an optional change right now, you don't have to amend your plan document until the end of the 2025 plan year. We have a little bit of breathing room, even longer for governmental plans. And I'm going to try to save some time at the end for questions. If we don't have time, I'll hang out. I'm happy to take whatever kind of questions that you have, but I have to give you fair warning. I cannot guarantee you that I know the answers to your questions just because there's so much that we don't know about Secure 2.0 right now. The next 3, 4, 5 years, the IRS, the Department of Labor, the PBGC are going to be very, very busy giving us guidance on Secure 2.0. So there's a lot we don't know, but let's start with talking about what we do know. And as we go along, I'm going to try to give what I label as kind of practical pointers from a practical point of view of each of these things as we're talking about implementing them in your retirement plan. This is one that's, as we discussed this morning, is kind of the top tier or one of the top tier items from a policy perspective. Any new 401k or 403b plan is going to have automatic enrollment, specifically an eligible, an eligible automatic contribution arrangement, an EACA. What's an EACA? Well, an EACA, there's a specific requirement for EACAs that the default rate has to be uniform. That is to say, the default rate has to apply the same to all participants. And there's some flexibility here. So the initial default rate, you can set it anywhere between 3% and 10%, also has to have an automatic increase. It's 1% per year, 1% per year. It's not at least 1%, it's 1% per year, no more, no less. That's what it says in the statute. It can go all the way up to 10%, but no higher than 15%. So there's a little bit of flexibility in setting your default rate. We do have to allow participants to take a 90-day distribution window. That is to say, this always happens when you set up automatic enrollment. You have to send out notice to the participants before the automatic deferrals start. And there's always participants that don't read it, they throw it away. And once they start seeing in their paychecks, hey, wait a second, where's my money going? It's going to the 401k plan. I'll take cash, please. So they just want to receive the money through their paycheck. There's a 90-day window that they have to undo the deferrals they've already made and get them out of the plan. Once that 90-day deferral closes, they can stop future deferrals if they want. But the money that's already gone in stays in. And the default investment has to be a QDIA. Most commonly, that's target date fund, but we see managed accounts becoming more popular as QDIAs as well. So it's not effective until 2025. Well, how does that work? Here's the way it works. If your plan was established before the effective date of Secure 2.0, which was December 29th, 2022, you're grandfathered, you don't have to worry about it. If it's established after that, you have to have automatic enrollment, but it's not necessary that you have automatic enrollment in your plan until 2025. So if you had a startup plan, that's effective date was January 1, 2023, you don't have automatic enrollment, that's okay. The automatic enrollment doesn't have to kick in until 2025. There's a number of exceptions here, as we talked about grandfather plans, plans that were in existence at the state, at the date that Secure 2.0 was passed into law, government and church plans, companies and businesses less than that have only been open for less than 3 years, simple plans, and also very small companies, less than 10 employees. So here's my practical pointer on this one. I think I talked to a lot of people who say, you know what, our plan's been up and running for years, so we're grandfathered, we don't have to worry about it. All right, fair enough. But if you are a company that is in acquisition mode, you pick up a lot of new acquired companies as we go along, mergers, maybe you're buying subsidiaries of another company or a division of another company. Frequently, M&A activity triggers a new startup plan. So the question becomes, is that startup plan, because of your acquisition of a new company, is that going to be subject to these rules? Particularly if there's a spinoff from the old plan. I'd like to say that in a spinoff situation, these rules won't apply because the new plan is really a continuation of the old plan that's been spun off. But we don't know that for sure. We're just going to have to wait until we have guidance from the IRS. Something to keep in mind if you're working with companies that have a lot of acquisitions. This next change is something that kind of is derivative of Secure 1.0. Before Secure 1.0, the rule was maximum eligibility waiting periods in a retirement plan were 1 year of service. That's 1,000 hours in a 12-month period. Secure 1.0 added the new rule that if you have any employees, they never get a year of service because they don't work enough hours. But if they have 3 years, 3 consecutive years with 500 hours in each, now you have to allow them to participate in the plan. And it's only for the elective deferral portion of the plan. You can still say for any employer money, you got to wait until you get a full year of service. But anybody that has those 3 consecutive years with 500 hours, now they have to be allowed in for elective deferrals. Secure 2.0 reduced that 3-year wait to 2, effective in 2025. So if you have someone that has 500 hours in 2023 and 500 hours in 2024, that person has to be let in for elective deferrals only as of 2025. So here's my practical pointer on this one. I think I see a lot of companies that are changing their eligibility rules, shortening their eligibility rules. When this provision came out in Secure 1.0, there were just a lot of questions around it. We got proposed regulations now, but even after we got those proposed regulations, I think there's still a lot of questions about how do we administer this? How do we do that? Now we got something new that we need to track. It's just kind of a headache to do all this. And now it's even shorter. So I do see a number of companies deciding, look, we're just going to make it easier to get in the plan. Because if you have immediate eligibility for everybody, you don't have to worry about these rules at all. Now, I will admit, part of what I think is driving that, the shortening in eligibility waiting periods and retirement plans, part of it, I think, is the tight labor market. And sometimes when you have a retirement plan, you got to wait a long time to get into it. That can be a real detriment when you're trying to recruit new people. So I think that's one reason, but I also think that there are plan sponsors that just want to avoid having to deal with these new rules for part-time, long-term part-time employees and are just shortening their eligibility. So if you require a full year of service for part-time employees to participate in your plan currently, and you want to avoid all this headache, maybe it's something to think about to shorten your waiting period for elective deferrals only. You don't have to change your waiting period for employer money, right? You only shorten it for elective deferrals. You get around these headaches. You don't have to put any more money because all they're becoming eligible for is elective deferrals. So I see a lot of companies doing that. The one caveat I'll add is, I think before you do that, you need to think about the impact that that's going to have on your non-discrimination testing. If you think opening this plan up to a lot of part-time employees that are now able to defer but aren't going to defer, is that going to throw your ADP test off? So you kind of need to look before you leap on that one, but it's something to consider. Do I want to change my eligibility rules to not have to worry about this? This is another one that we talked about this morning. Starting in 2024, if your plan has catch-up contributions, anyone that earned $145,000 in the prior year can still make catch-up contributions, but can only make them on a Roth basis. If you earn less than $145,000 in the prior year, you can still make pre-tax catch-up. I think of all the questions, of all the subjects from Secure 2.0, this one for me is driving the most questions. I just get lots of people asking, okay, how does this work? How does that work? I think there's some there's a lot of plans that are kind of struggling with figuring out, okay, how do we track who's under 145,000 and who's over 145,000? If they'd used the HC versus NHCE status, that would have been easy because we're tracking that for everybody already, right? But this is one more thing that we have to track, kind of creates a headache. Another question I've been getting is sometimes we reclassify funds as catch up after the fact. For example, if you fail your ADP test, you got to return some money back to HCEs. One way of fixing that is rather than returning money to the HCEs, convert that money to catch up. Well, what if they put it in pre-tax? Can you no longer do that? Can you retroactively reclassify it as Roth? Just a lot of questions about exactly how this one is going to work. I'll also point out this. Most plans right now offer Roth. The overwhelming majority of plans right now offer catch-up. If you don't offer Roth, and you have somebody in that $145,000 category, they're not eligible for catch-up. And the way the statute is worded, nobody's eligible for catch-up. So I really think this is going to drive even more plans adopting Roth for their elected deferrals for participants. If you don't have Roth in your plan, now's the perfect time, I think, to stop and think, do I want to add Roth to my plan for these purposes? Another thing I've heard people talking about is, well, maybe we should just make this simple and have a rule that all catch-up contributions are Roth. Okay, there's nothing in Secure 2.0 that prevents that, but I really want to wait and see IRS guidance on that. And here's why. When Roth originally came out years and years ago, Treasury regulations were issued that made it clear you can have a 401k plan or a 403b plan that's pre-tax only, no Roth, but you cannot have a 401k plan that is Roth only, no pre-tax. Is it possible that the IRS is going to take that same position with respect to catch-up contributions? I don't know. We're just going to have to wait and see. If the IRS allows that and all catch-up is Roth, I think that might simplify things, but we're just going to have to wait and see what the IRS has to say on that. All right. There are two new emergency distribution options. Here's the key thing to remember. Both of these are optional. So that means you can decide, I don't want to add either one of these to my plan, or you can decide, I want to add this one, or I want to add that one, or you can decide, I want to add them both. There's complete flexibility. Option number one, did I hit something wrong? Okay. Option number one, they each have their advantages and disadvantages. This one is very straightforward. It's simply adding a rule to your plan, and it's effective in 2024, saying participants, any participant can take a distribution from the plan for an unforeseeable or immediate emergency up to $1,000. And you can rely on the participant's written certification that they have actually experienced an emergency and need the money. So the upside of this one is that it's very simple. It looks very straightforward to implement. The downside of this one is that it's only $1,000. So if your car needs new tires, it'll probably cover that. If your car needs a new transmission, this one isn't going to get you very far. So that's the pluses and minuses of this one. Both of these distributions are exempt from the 10% early penalty tax if you take a distribution before age 59 and a half. And this one, the rule is you can repay it. You don't have to repay it. If you choose to repay it, then you can take another $1,000 distribution in the following year. If you don't repay it, you got to wait 3 years. And repayment can be made just straight through a payment from the participant to the plan, or making new deferrals into the plan. Those new deferrals can count as repayment as well. The other alternative, the pension-linked emergency savings accounts, not long after Secure 2.0 came out, I remember talking to someone, they were like, well, what about the PLESA? What are we going to do about the PLESA? Do we think of the PLESA? I'm like, PLESA, what? And then it clicked for me. Pension-linked emergency savings accounts. Okay, that's a horrible acronym. Let's all agree right now, we're not going to use PLESA. We can use emergency savings account. We can use sidecar. I've heard that kicked around as well, because that's exactly what this is. It's a sidecar. It's only in defined contribution plans, and it's a separate sub-account that gets set up for each participant. or participants that choose to do it. Only non-highly compensated participants can choose to put money into the sidecar. All money going to the sidecar has to be Roth, and all money going to the sidecar has to be employee deferrals. It cannot be any employer money. And the statute is clear that you can set this up as an automatic enrollment if that's what you want to do. So the money goes into the sidecar. It goes in on an after-tax Roth basis, and then the participant has pretty much as much flexibility as they want to get the money out, as much as one distribution per month. The advantage of this one is the amount, as you can see, is a little bit higher, $2,500 as index. So it's a little bit bigger of a boost for that participant when they need that emergency savings. The downside is, as you can imagine, just looking at these rules, it looks like it's going to be much more complex to administer than the prior option. And this one also, any distributions are exempt from the 10% penalty. And you don't have to pay income taxes on this one either because they went on a Roth basis. So when we think about this, we want to think about, okay, do we think we have, and this is your practical pointer, do we think we have an employee base that would be more likely to defer if they knew they could get funds out of the plan if I need a new set of tires? Do we think it's going to move the needle based on our individual employee workforce? And the other thing we need to start thinking about, because these don't go into effect until next year. The other thing we want to start thinking about is how much complexity are we willing to take on? I talked to companies, a lot of them that are saying, I think for now, we're just going to go with the first one because it looks simpler and easier to administer. We might consider the other one down the road, but we're just going to want to let kind of the dust settle on that and see, what the experience is, given how complex it might be. Higher catch-up contributions. This is another one we touched on earlier this morning. So the rule is once you turn 50, starting in the year you turn 50, you can start deferring more than your 402G limit. 402G limit for 2023 is $22,500. The catch-up for 2023 is $7,500. Once this rule goes into effect in 2025, during the year the participant turns age 60, 61, 62, and 63, they have a higher catch-up limit. The catch-up limit is the greater of $10,000, and that number is indexed for inflation, or 150% of standard catch-up limit. Unless Congress changes that $10,000, it's always going to be 150% of the standard catch-up limit. As I said, the catch-up limit for 2025, $7,500, and 150% of that is well over $10,000, and that gets indexed for inflation as well. So it's always going to be 150% of the standard catch-up unless Congress does something to change that $10,000 number. So what's the practical pointer on this one? Well, to be honest with you, I really don't have one. I think, as I'd said earlier, the overwhelming majority of plans that I see have catch-up contributions. I suspect that the plans that have catch-up contributions are going to add this. There's really no downside to it, right? It allows more flexibility to your participants. It allows them to put more money in, and I'm not sure that there's really a downside to doing it. So I expect that starting in 2025, this is going to be picked up pretty commonly. All right, more about Roth. People use the term Rothification. Rothification refers to the idea of making more Roth contributions mandatory, or making contributions that were previously only available to be pre-tax to be Roth if the participant wants it. So optional Roth. That's the term of Rothification. As we covered this morning, there's no policy behind this. It's not like there's somebody in Congress saying, we think Americans are really better off saving on a Roth basis. It's a matter of budgetary considerations. It's a matter of raising money because the money comes in sooner. Doesn't mean that the government is going to bring in more money, you understand. In fact, probably the opposite, but it means the money is going to come in sooner. So the rule before Secure 2.0 was you can establish your plan to say elected deferrals can go in on a pre-tax basis or Roth basis based upon the election of the participant, but the employer money has to go in pre-tax. It cannot go in on a Roth basis. Effective now, you can change the rule to say that employer money at the election of the participant can go in on a Roth basis. And this is an optional provision. You don't have to add it to your plan if you don't want to. But if it's something that you want to add, if it's something you think your participants would like or want to use, it's available. There's rules in the statute that encourage it in the sense that they try to make it as painless for the plan sponsor as possible. For example, it shouldn't really impact your non-discrimination testing. So the practical pointer that I have on this one is, as the last bullet point says, this is effective now. The statute says this is effective for any contributions made after the enactment date of Secure 2.0, which is the end of 2022. So even if there were any contributions in 2023, in January or February, made for the 2022 plan year, this rule from a legal perspective was available. But it wasn't available from a practical perspective, still isn't. And the reason is, record keepers just aren't set up right now in a way that would allow for this type of option. We suspect it'll happen in another year or so, but right now no one's set up to do it. So if you want to start doing this right now, here's my practical pointer. Talk to your record keeper and find out, when are you actually going to be able to start administering this rule, because we might have some interest in it. This one, let's just cover quickly. So the rule is you can't force out a distribution to a participant. Participant has to consent to any distribution. The exception is if the accrued benefit is under $5,000. Now that $5,000 number is not indexed for inflation every year. It's $5,000. It's been $5,000 for years and years and years from when Congress changed it. It was $3,500 years and years ago. They were increased it to 5,000. Now they're increasing it to 7,000. Not sure that there's any really practical pointer there. Not all plans do this, but I do think the plans that allow for force outs without consent, everybody's going to raise it from 5,000 to 7,000. There's no reason not to. All right, permitting small financial incentives for deferring into a plan. Before Secure 2.0, the statute was written such that the only thing you can give a participant to encourage them to defer into the plan is a matching contribution. You can't give them anything else. You can't deny them anything else. So Secure 2.0 changes the rule effective now to allow us to give small financial incentives to defer into a plan. And as Preston covered this morning, the real concern here is it doesn't define de minimis. It doesn't say what's small. You know, honestly, I think if you were giving $25 gift cards, no one's going to give you a hard time for that. This morning, Preston suggested might be as high as 100, might be as high as 200. We'll have to wait until the IRS guidance comes out on that. If you're thinking about this, I'm not a behavioral economist, right? But I do know, I talk to people who at their companies plan optional meetings or optional events, those types of things, and they will tell you food gets people to turn out, right? If you offer that, if you say, hey, there's this optional meeting, nobody shows up, next time you do it as a lunch meeting and offer lunch and everybody will come. I've been told that even schedule a morning meeting and have donuts, something as simple as donuts, people will show up for that. And so, you know, I think this is something that has the potential to really work, even if it's something as small as a $25 gift card. My practical pointer is talk to someone at the company where you work, organizes those types of things, optional meetings, optional activities, optional things. Talk to the people that at your company that schedules optional things and ask them, what gets people to turn out? What really moves the needle here? And that's what you want to focus on. Whether it's food, maybe it's a gift card to go get something to eat, or gift card for coffee, or whatever it is. Know your workforce the best. And there's somebody, I guarantee you, at the company that you're at that knows exactly what's going to turn out your specific workforce. So the required beginning dates are also being increased. Before Secure 1.0, your required beginning date was the later of age 70 and a half or retirement. Different rule for 5% owners. With Secure 2.0, it increased to 70, the later of 72 or retirement. Now it's being increased to the later of 73 or retirement, and eventually in 10 years to the later of age 75 and retirement. And this is how it's laid out in the statute. It looks a little complex, but it's as simple as this. If you were born between January 1, 2050 and December 31st, 1959, did I say 2050? January 1st, 1950 and January 1st, 1959, your required beginning date is age 73 or retirement, whichever is later. At least that's the way the statute was intended to work. And that's the way I think it's eventually going to end up working. If you were born January 1, 1960 or later, your required beginning date is the later of age 75 or automatic enrollment. So here's my practical pointer on this one. I see a lot of people labeling this as a mandatory change. I see a lot of secondary sources labeling this as a mandatory change. So it's an increase in the required beginning date. You got to do it. You don't have a choice. I'm not ready to concede that, and I'll tell you why. Years ago, before Secure 1.0, the last time required minimum, the required beginning date was increased was, I want to say, the Small Business Job Protection Act. Before that, the age was at 7.5. Small Business Job Protection Act changed the rule to the later of age 7.5 for retirement. And about a year after the Small Business Job Protection Act was passed, the IRS came out with regulations that said, this is optional. If you don't want to do it, you don't have to do it. And I think there were defined benefit plans that didn't want to do it. And I think there were defined contribution plans where the employer also had a defined benefit plan and they wanted everything uniform. So the defined contribution plan didn't do it either. So my point is, I don't think if this is something you don't want to do, you want to keep your old required minimum distribution, just keep your eyes and ears out, because I think it's very possible the IRS comes out with similar guidance on this. Other changes to RMDs. If you miss a required minimum distribution, currently there's an excise tax, 50% of the missed distribution amount. Excise tax is not paid by the plan administrator or the plan sponsor or the record keeper. It is paid by the participant. Secure 2.0 reduces that 50% excise tax down to 25%, lower down to 10% if you correct it within 2 years. And I'll be honest with you, I think it's extremely common that the IRS waives this excise tax. The taxpayer just says, well, the record keeper didn't tell me, and so the IRS waives it. I think it's far more common that the IRS waives this excise tax than actually enforces it. Nevertheless, I'm still happy to see a reduction in the excise tax for the unusual situations where it's actually paid. That's good news. Here's another change involving Roth. If you have money in a Roth IRA, there are no lifetime income distribution rules. You could live to be 115, leave that money in your Roth IRA for as long as you live and not take a cent out. In retirement plans, the RMD rules will apply. That's changing effective in 2024. The retirement plan rule is becoming similar to the IRA rule. So that means starting in 2024, if you have Roth money in a 401k plan or a 403b plan or a governmental 457b plan, you don't have to take it out during your lifetime. You can leave it there for as long as you're alive. And that, I think, is my practical pointer for this slide. I think this is a subject that we really need to communicate to participants, because the decision to, do I put money in on a pre-tax basis or do I put it in on a Roth basis? That can be a very complex decision. There's a lot of factors that you have to consider. There's certainly no one size fits all. But this is another factor that you want to consider, particularly if you are an individual who would like to leave a legacy to your children or your grandchildren. This is a tasty change. So I think this has the possibility to impact decisions as to whether money's going in pre-tax or Roth. And it's our job to make sure participants understand this rule change. It's for 2024. And last, this is also a rule change that makes retirement plans consistent with IRAs. If the surviving spouse is the 100% beneficiary of a deceased participant's account, that surviving spouse can treat it as their own account, which means they can defer, particularly if they're younger, right? They can leave it in the plan for a little bit longer. Here we are. I went too far. All right. Hardship distributions. There are some, I think, really positive changes relating to hardship distributions. Before Secure 2.0, the Treasury regulation said, participant is asking for a hardship distribution. You can rely on a written certification from that participant that they do not have any liquid assets to cover the expense. Now, after Secure 2.0, it's written straight into the text of the Internal Revenue Code. Not only can you rely on the written certification of the participant that they don't have any liquid assets, they need to take a distribution from the plan in order to pay this hardship expense. You can also rely on their direction, a written certification that they have, in fact, had a hardship event. For example, a standard hardship event, which would be a burial within the family, post-secondary education expenses for you or your family, medical bills, foreclosure. You can rely on that, the written certification for that. And you can also rely on the written certification that the amount that they're asking for is the amount that's necessary to cover the expense plus taxes. So hopefully this will streamline hardship distributions in 401k plans and 403b plans. It's effective now in 2023. Governmental 457b plans don't have hardship distributions, but they do have unforeseeable emergency distributions, and these same rules are going to apply to them. The last bullet here, the Bipartisan Budget Act from, I want to say 5 or 6 years ago, made some rule changes for hardship distributions to 401k plans. Secure 2.0 makes the same changes for 403b plans. Here's the most significant one. If you have 403b, a 403b plan with hardship distributions, it expands the sources that those hardship distributions can come from. For example, if you have a safe harbor 403b plan, you can take a hardship distribution from that safe harbor source. So there's a number of changes here. Here's my practical pointer on this one. The statute says the IRS may, it does not say the IRS must, it says the IRS may adopt regulations saying that you can rely on these written certifications of participants, but you can't rely on them if you have actual knowledge to the contrary. In other words, if you know that the written certification is not correct. We'll see what the IRS does there. I suspect the IRS will eventually come up with regulations that say that. In the meantime, I will remind you, distribution decisions are fiduciary in nature. If you are deciding, is this person eligible for a hardship distribution? That's a fiduciary call, all right? And when you are making a fiduciary call, my humble suggestion to you would be do not rely on a written certification that you know is false. So and before the IRS regs come into rule, that's something to keep into effect. If you know these written certification is false, my suggestion would be you not rely on it. All right, the next couple of slides, there are a number of new distributable events added by Secure 2.0. And we're going to kind of try to run through them quickly. And these are all optional. You'll have the option to add these to your plans when it becomes effective, but none of them are mandatory. Optional number 1 is a distribution for victims of domestic abuse. If any participant has experienced domestic abuse in the last 12 months, they can take a distribution up to $10,000 that's indexed. The good news for plan administrators is you can rely on the written certification of the participant that, yes, I'm the victim of domestic abuse. You don't have to investigate their claim. You don't have to dig into their personal lives. Is somebody really beating them up? You can rely on their written certification. And domestic abuse is defined in the statute to be quite broad. So I think this is, I suspect a lot of plans are going to adopt this. It's not eligible until 2024. And like all these distribution triggers, participants have the ability, you have to give them the right, the ability to repay it within 3 years if they want to do that. They're not required to repay them, but if they want to repay it, the plan has to give them that option to repay it within 3 years. And also, these distributions won't be subject to the 10% excise tax on early distributions if the participant is under age 59 and a half. So that's new distribution trigger number 1. This one I struggle with because if you read the statute, there's nothing in the statute that says you can distribute, you can use a terminal illness diagnosis of a participant as a basis for making a distribution. So we're not adding a new distributable event. What it does say is if you're a participant, you're taking a distribution from your plan, you're terminally ill, you don't have to pay the 10% excise tax. So if you're taking a distribution from your plan, maybe a hardship distribution to pay medical bills, maybe you terminated from the employer. If you're taking a distribution and you're terminally ill, you can avoid that 10% early distribution penalty. Terminal illness is certified by a physician as having an illness or physical condition, which can reasonably be expected to result in death in 84 months or less. That's 7 years. And participants have the right to repay it, which kind of blows my mind. When there's no distributable event, why would you give them the right to repay it? But terminally ill participants can repay their distributions. Disaster relief distributions. Not too long ago, every time there was a massive natural disaster, Congress would, pass some type of rule providing some type of relief for plan participants through their retirement plans. Congress can't keep up anymore. They don't want to do that anymore. So they simply passed a new rule that allows, and it's optional, but if your plan document allows it, and you're impacted by a natural disaster, you might be able to take a distribution. There's two requirements. You have to live in a federally declared disaster area. Prior versions of these rules that applied to specific natural disasters said live or work. But if you look at Secure 2.0, it just says live. So number one, the participant has to live in a federally declared disaster area. Number two, they have to sustain economic loss as a result of the disaster. And economic loss can be fairly wide open. It includes something like loss of earnings. Exempt from the 10% distribution penalty, can be repaid within 3 years. That it's $22,000. It's not $22,000 per year. It is $22,000 per natural disaster. So if you live in Florida, good news, you might be able to take more than one disaster distribution per year, up to $22,000. And this one also has a very special rule. It's the only one that has this rule. If you decide not to repay it back into the plan, you can include it in your income ratably over a course of 3 years. So it kind of softens the blow. And one last one, long-term care. This doesn't start until 2026, but starting in 2026, if you want to offer this, you can. It allows any participant that has a long-term care policy to take a distribution from plan to pay the premiums on the long-term care policy. Up to $2,500 per year. It's also limited to the amount of the premium. So if the premium you have for the year is only $2,000, that's your maximum distribution for the year, $2,000. And also it's exempt from the 10% penalty for early distributions. Okay, so what's my practical pointer on the new distribution triggers? I think it's very easy to look at all these new distribution triggers and just be tempted to go hog wild, right? If we think this is going to encourage our participants to defer into the plan, let's start adding these. And maybe that's what you want to do. But you also want to think about leakage, right? Leakage, the idea that these are retirement funds and we want these funds to be there for the retirement security of the participant. We don't want them going out for non-retirement related reasons, or at least we want to limit that as much as we can. So we also want to think about, by adding all these distribution triggers, are we worsening our potential leakage problem? And there's no one size fits all answer to that question. It depends on your specific workforce. But I would suggest before you think, yeah, we're going to add these, give a little thought to the leakage problem. Paper statements. You know, most of the changes that we see in Secure 2.0, people are really happy about them. We think, you know, they're moving, as I think I said that at the beginning, right? Generally, these changes are moving retirement policy in a positive direction. This is the exception to the rule. This is one rule change that I think plan administrators and plan sponsors are really not happy to see. In recent years, it's become more and more easy to provide required disclosures to participants electronically. Particularly the Department of Labor has moved with guidance that's making it easier to provide electronic disclosures. Congress is pushing back on that a little bit. The rule here is, starting in 2026, if you have a defined contribution plan, at least one benefit statement per year has to be in hard copy. And if you're a defined benefit plan, at least one hard copy pension benefit statement every 10 years. So as I said, I think there are a lot of plan participants that are plan sponsors that aren't really particularly happy to see this one. The statute does say explicitly, if a participant affirmatively elects to receive the pension benefit statements in electronic format, that's fine. Then these rules don't apply. You can give them all in electronic format. I don't know if that means we're going to try to move more towards getting affirmative confirmation, but participants are willing to do that. Not sure I really have a practice pointer here. We're just going to have to bite the bullet and swallow this one because I don't think anybody's happy to see it. But here's one disclosure related item that I think everyone is happy to see. You don't have to give disclosures to unenrolled participants. What's an unenrolled participant? Unenrolled participant is a defined contribution concept. There's no unenrolled participants in defined benefit plans. An unenrolled participant is someone who has never deferred into the plan, so they don't have any deferrals, they don't have any match because they've never deferred into the plan. There's no non-elective contribution in the plan. So that person is eligible to participate in the plan, but they don't have any money there in the plan. That's an unenrolled participant. And both the Internal Revenue Code and ERISA have just tons and tons of required disclosures. For example, the DOL regulations require that if an investment in your lineup has a change to its expense ratio, you have to give that new information to participants. Somebody doesn't have an account in the plan. Why would they ever need that information? They don't. So if we have unenrolled participants in the plan, you don't have to give them any required disclosure under the code or ERISA. Of course, once they hit their entry date, you have to give them a summary plan description, and you have to give them an enrollment packet, and you have to give them a PIN, so they have the ability to go online and or make an election to defer if that's what they want to do. But if they elect not to defer, or if it's an automatic enrollment plan and they opt out, that's it. You don't have to give them anything else. You do have to, once a year, you have to give them an annual reminder. Hey, you're eligible for the retirement plan. We think it's probably a good idea for you to defer. But if you just remember, you're eligible. As long as we give that annual reminder notice, we don't have to give them anything else. I think that's a good development. Employee Plans Compliance Resolution System, the EPCRS. The EPCRS is the IRS correction program. And there are a number of changes to corrections on the IRS side under Secure 2.0. There's changes for participant loans that have gone wrong. There's changes for overpayments. There's changes in situations where you should have automatically enrolled someone and you didn't. There's a number of changes there, and they're all, I think, good to see. But here's really the best part. If you have an operational error it means you administered the plan in a way that's inconsistent with the Internal Revenue Code of the plan document. If you have an operational error with a couple of small, narrow exceptions, you can self-correct. Doesn't matter how far back the error goes. Before Secure 2.0, if it went back more than 3 years, we had to decide, is this error significant or insignificant? There's a number of factors you had to consider. No single factor was determinative. So it's just kind of a headache to have to go through that analysis. We don't have to go through that analysis anymore. If it's an operational error, it doesn't matter how far back we go, we can self-correct it. I think everybody is happy to see that one. Just two more. You know what? I'm going to try to go through these last two quickly because they were both touched on this morning, and I do want to save time for questions. With the retirement savings lost and found, as was discussed this morning, within 2 years, the Department of Labor is required to set up an online national searchable lost and found database, which means you can go in, put in your information, and it will tell you, hey, you remember that job you had 30 years ago? You've got money still sitting there, if you have money sitting somewhere. Department of Labor for many years has been concerned about missing participants and making sure that when someone retires, they know where their retirement assets are. This is part of that movement. And I think it's a good development. Here's the one practical pointer that I'll give you. What this means for you as people who work with retirement plans. Retirement plans, as a result of this, probably starting with the 2024 Form 5500, there's going to be additional questions for you to answer on that 5500 form. They're going to be asking questions about terminated participants. What terminated participants still have accrued benefits in the plan? What terminated participants have taken their benefits out, or the benefits have gone someplace else? What participants have terminated with 0 vested benefits? There's just going to be some extra questions that we're going to have to start answering on the 5500 that's going to generate this database. The savers match. This was also touched on this morning. We're taking the savers credit and turning it into an actual match. So if someone qualifies, you've got a low or mid-income employee, and they defer, they qualify for the savers match. It's going from a credit on their 1040 to an actual matching contribution the federal government actually makes to your actual 401k or IRA. Lots of open questions here. This doesn't go into effect until 2027. Lots of questions like, okay, how are we going to set up the process of allowing the participant to decide, here's where I want the money to go. But here's your practice pointer here. Here's the takeaway. Secure 2.0, the statute, is very clear. You do not have to accept this money if you don't want to. They try to make it easy for you. For example, you don't have to include this in your non-discrimination testing. There's a number of things like that. But it's also clear you don't have to take this money if you don't want to. So the question becomes, should you take this money into your retirement plan or should you not? And I would submit to you the answer is we don't know yet. We just want to we want to learn more information about how the system is going to work and what the money is. You got plenty of time to make this decision. It doesn't happen until 2027. So don't make the decision now, but understand at some point this is a decision that you're going to have to make if you're running a 401k plan or a 403b plan. All right. I've plowed through a lot of information in less than 50 minutes. I've left time for a question or two, if anybody has one. Yeah. Okay, so yeah.
In that particular segment, though, $145,000 that define that $145,000.
Yes. Yes. So let me repeat the question. So the rule was, if you made more than $145,000 in wages in the prior year, is that once you're at that status, you're earning more than $145,000 a year, any catch up that you put in becomes raw. How do we determine that $145,000? And it's FICA taxes, right? It's FICA wages. So there are certain types of self-employed individuals who, if you read the document, technically have no wages, right? Does this rule apply to them or not? I suspect that there'll be some forthcoming guidance on that. John has some. Do we have a microphone that John can use? Well, we have people listening at home, so. I'm going to start lifting weights any day now, I promise. All right. I loosened it up for you, ma'am. John, you had a comment.
Steve, you've done a really nice job.
Thank you.
Excellent presentation. Some would argue that the service may clarify that it doesn't say you're subject to FICA wages. It says it's section 3121 wages, and that's a definition of wages. It doesn't mean you're subject to FICA taxes. And so some have argued that it catches people with earned income rather than W-2 income are hit by this as well. But I think your point you made that it's not the definition of compensation we're used to keeping track of under a plan is unfortunate and important. And the stories are, I think, that a certain senator from Iowa just wanted to know how much funding we need, where's the cutoff? And the advisor said, okay, it's 145,000.
Right. Yeah, and I was discussing this with someone earlier today that $145,000, that money is so close to HCE status. Why didn't they just say HCE instead of 145,000? Thank you. It would have made it much easier for us to track this and to implement it, but it is what it is. And as John pointed out, yeah, we think there's just going to be more guidance. There has to be more guidance on that issue coming out. A lot of questions on it. All right, we're a minute over. So I'm happy to hang out if anybody has any questions. Like I said, I can't guarantee you I have answers, but I'm happy to address them. Thank you very much.